Okay, this video is going to be about the standard of a free and appropriate public education. This would be applicable during this time period, but I'm also going to sort of speculate how somebody like me in my office or how I'm directing my staff to how we're going to be interpreting things in the near future. Until, of course, we get some additional guidance from the Federal Department of Education because the Congress did pass a $2 trillion stimulus package, which included granting limited waiver power to the federal government or the Department of Education on a federal level. We don't know yet what those limited waivers will entail, so it's absolutely crazy to speculate at this point. I already did a video on that anyway, what I think it's going to be, so I don't want to rehash that. But I wanted to do a series of videos. That way you can sit there and look at the title and determine what's applicable to you. So the standard of a free and appropriate public education by law isn't going to change. Okay, I don't think it can change. In fact, it's an aspect of this law, which is the Civil Rights Act. And I haven't looked at what ended up passing as far as a $2 trillion COVID-19 emergency package. At the same time, if it's similar to the language that I saw prior, then it already has a clarifying statement in there that the Secretary of Education doesn't have a power. It doesn't have the power to um, do anything that impedes the civil rights of particular acts. Okay, and so these limited waivers would I'm here I am going back and sort of theorizing. I'm just telling you that I don't believe that the standard of a free and appropriate public education is going to be um, infringed upon. How about that? Now, do I believe that the standard of analysis, because now due to the safety and health issue, the only way that we can serve children is through remote learning, distant learning, however you want to put it. So therefore, when you have the continuum of alternative placements, least restrictive environment, at that point, O1 is out of the question. Okay, it doesn't exist right now due to safety and health. So because that isn't where we are on the continuum and it's not even available to our kids, that means every IEP changes. Now you can sit there and say, well, we are going to try to provide services on a comparable level. Well, comparable level per the status of the child on that continuum. Okay, because I have clients all the time that for whatever reason were a 0-1 LRE, which was majority of their day in general education, but then there needed to be a temporary homebound situation, which then moved them along that continuum of alternative placements where their LRE was temporarily homebound. Well, every child right now is sort of in a temporary homebound status, but we can't call it homebound because it's not homebound. So that's where this safety and health factor comes in, and now it's somewhere else along that continuum. And there's nothing wrong with us sort of inventing places along the continuum. We allow that kind of flexibility to IEP teams, and during these kind of state emergencies, then we've got to be flexible. So to a level that the school can, considering the safety and health status along that continuum, yes, they would need to provide comparable services to their good faith abilities under that situation. IEP teams will need to meet in order to make these adjustments. Because once again, I recommend that you're flexible. I recommend you work with your team. I recommend that you don't be a major horse's ass during this time period when everybody's trying to figure this out. Okay, I can sit there and cast blame later. All right, but right now isn't the time to do it. Now, so what have I told my team with regards to a free and appropriate public education? That standard we were the majority of the way through the school year, 75%, in fact. If you look at it in 9-week increments, first 9 weeks was fine, second 9 weeks fine, third 9 weeks fine. It's that fourth 9 weeks that we have an issue with. So with regards to our analysis, most school implementation dates on the IEP meeting run from August until May. We're 75% done, which means that on some children's IEP, the school's going to be able to say that the child made tangible, measurable progress on the goals adopted for the 1920 IEP that runs from August until May. Some IEPs and some parents have got to sit there and say, yes, my child did make good progress. And at that point, that's how we're going to be basing our analysis is off that August to March. And then what we're going to do for March until May is sort of take it by a case-by-case situation. What geographically, where is that school? What kind, when did they start making attempts, good faith attempts to provide comparable like services to the child? How communicative were they with their families in trying to coordinate something that was feasible, workable, and agreeable? Okay, and were they able to implement during that time? And this is sort of going to be that case by case. Our analysis is going to be that same traditional analysis that we always apply, that we've always applied, and what the legal status dictates from August until May. And if the child had not made measurable progress as of March, I can tell you whether it was COVID-19 or not, I haven't seen a school system yet that if a child hadn't made measurable, tangible progress by March, then they sure as hell weren't going to have a good shot of making it for the last 9 weeks of the school year, just massively just making all these improvements. So I don't see a lot changing on our end how we would do that analysis, okay? But at the same time, am I going to adjust our analysis per that standard where the child's LRE is on this safety and health aspect of the continuum to where it's a good faith attempt, and I'm going to sit there and hit all those boxes as far as how receptive the school was, or how communicative, how transparent, how collaborative, what options were out there for each family. And as this unfolds, we'll have a better idea of what that is, okay? But it's not going to be a uniform approach, and you should not expect that, because the kids in this county don't have accessibility to the kids in this city school that are in the metro area with full broadband. This school already has moved, for example, to digital learning. Everybody gets an iPad, for example. It's going to be so much easier for them, for example, to have more of a uniform type, and the kids that they have to sit there and really make some efforts in is more of the moderate to severe impacted kids. That's where it's going to get tricky for them. But like I said, the standard of FAPE remains the standard of FAPE legally. All right? It's just the analysis is slightly different, and there's going to be a little bit more adjustment. And I'm not going to say flexibility. It's just going to be a slightly different analysis based upon good faith efforts, the health and safety standard because of the declared emergency, comparable nature of services.